I want to discuss a topic that comes up ever so frequently in the New York wage and hour practice, and that is the failure to pay a bonus. Uh, New York has an interesting statute. It's called Labor Law 193, and what it states, really in its simplest form, is that an unlawful wage deduction is actionable under the New York labor law. And that's important because a violation of the wage and hour provisions of the New York labor law generally come with 100% liquidated damage penalty, and they come with statutory attorney fees. And those two, penalties really amplify the value of these cases. There's also generally 9% prejudgment interest from what we always say is the midpoint of when the violation occurred. So these are significant claims. And the thing about bonuses is that, unlike most other areas of the New York wage and hour law, which really deal with, I think, in most part, hourly workers, commissioned salespeople, this is the one portion of the wage and hour law that really deals with your white collar worker, with your stock executive, with your banker, with people who, are not making 15 or $16 an hour, but are making six, seven figures, significant sums of money, and the bonus itself is clearly commensurate with that salary. So these claims are worth significant sums of money, irrespective of any liquidated damages and irrespective of the attorney fees. And generally, these claims are also subject to a common law breach of contract cause of action. But what puts them into the sphere of we call this labor law 190 unlawful wage deduction? And what brings it there is the difference of whether or not this bonus is discretionary or whether it's non-discretionary. And the test that's used, and there was just another court case the other day, which is what got my attention on this topic, is whether or not you did something to earn that bonus. Uh, as I understand the law, essentially, if you're a stockbroker and you make a certain amount of trades per year and you're guaranteed a certain sum of money, an employer's failure to pay that sum of money after the vesting of the bonus occurs, that is, you did everything that you were supposed to do. You sold what you made 80 or 100 trades, you brought in Y amount of dollars for the firm, your bonus is Z, right? It's a promise. You fulfilled all elements of your promise. Boss says, well, glad you did that, but we're not going to pay it to you. Oh, we're going to fire you. Oh, and since you're not working here, we're not going to give you the money, right? And in that scenario, courts have held that the firm has violated labor law 190, 193, because that is a non-discretionary bonus, non-discretionary payment. There was an agreement that was made, right? You do X, you get Y, right? Y is a defined sum of money, you know? In other words, you did X, you made Y, right? And then Z is your bonus. So you did X, you did Y, you get Z, and then boss says, I'm not going to pay you Z. Uh, that should be contrasted with a lot of, I would say, majority of bonuses that a lot of you are familiar with, where you work 11 or 12 months. There's no promise or anything. You work, you make 80, 100, 150, whatever you make a sum of money. And then comes December time, boss comes around and gives everyone 10, 20, 30,000, five, pick a number, right? And then you didn't get your bonus, but everyone else got their bonus and you're upset. And then in that instance, you say, oh, well, that's not fair. This was, in my mind, a guaranteed bonus. It was promised to me, although there's nothing in writing to substantiate it. And then, you decide to file a lawsuit against your employer saying, I'm entitled to lose $5,000. Courts are, well, one, you probably would lose your breach of contract cause of action. Putting that aside, courts would say that that bonus that you didn't get is discretionary. That is, it's up to the whim of the employer. There was no promise. That bonus never vested. You never did anything to guarantee your payment of that bonus. And because it never vested, the right never vested, it was within the caprice or within the whim of the employer, the 193 cause of action does not lie in that particular instance. And it's just something, maybe when you're negotiating a contract with your employer, if you say, okay, well, we'll agree at $120,000 a year after 11 months if I meet a certain subject criteria, right? So you got to define the criteria. I am entitled in month 12 to a bonus of, pick a number, right? If you have an agreement that's like that, and then your employer decides they don't want to pay you after you have vested, that is, you have met the conditions, then that becomes a non-discretionary bonus. And if the employer decides they don't want to pay you after your right vested, well, then you have a significant cause of action against your employer. Hope for those of you watching, you find this advice or knowledge on the world of bonuses in the state of New York helpful. Thank you.